think it makes me look old.
It's professorial. Cambridging. My daughter comes in, someone tells me they like it, it just be nice. She hates it.
Carry it, can't take it out.
Just be but the color says because of pain. That's great.
How are you?
All rise. Circuit Court is now in session with the Honorable Pamela Gamble, Circuit Court Judge presiding.
Good morning, everybody.
Good morning.
So thank you all again for sending me the notebooks so I could read them all. I thought at some point today I want to see you, show you how I have some of the things organized so that you can see if there are things from prior hearings. You don't have to send them to me again because I have them all organized in a fashion that makes it easy to get to. So you don't have to keep your copy. All right, so it seems to me that we have a number of things to talk about today. I don't know that it's going to take the full day that we have set aside, but I have the defendant's motion to dismiss on grounds of fraud on the court with the corresponding motion to determine confidentiality, the defendant's motion to compel the plaintiff to produce documents with the corresponding motion to determine confidentiality, and the defendant's motion to access or for access to the corrected and unredacted DVDs that were produced by the FBI judge case. And we want to talk about the juror questionnaire. I did receive the defendant's second questionnaire, but I haven't seen what the parties have agreed to for the first one, so we'll talk about that. And the plaintiff's motion for issuance of letters rogatory to request documents from Jeffrey Denton, Adrian Wilhelm Weinbrecht, and Rebecca Denton Weinbrecht, and the United Kingdom. Anything else that we need to talk about today? Mr. Berlin?
I don't think so, Your Honor.
All right, Mr. Berlin, you want to first start with the...
Judge, one thing, if we have some time, is maybe to continue our dialogue just about pretrial jury selection stuff, if we have a few minutes.
I'm sure we'll have plenty of...
Okay. That would be
And I think that sort of corresponds with the jury questionnaire issue. And as a segue to that as well, I would like to go over the process so that there is an agreed upon colloquy that the court says to those jurors. And I think that sort of goes along with the first questionnaire, so we can talk about
the preliminary statement and
Yes.
so forth, which probably should be a little different in this case, I would think, just a little more substantive than normal. So.
To some degree.
Okay.
I think there's probably a two-way. One is the first way is once we get rid of the folks that can't be there for the lengthy trial, and then when we get maybe a different colloquy, or there would be a different colloquy when we get to the part of the folks that we're really going to be spending more time with.
Understood. I agree.
Thank you. All right, Mr. Berlin.
Your Honor, before we take up the substance of the motion to dismiss, I thought it might actually be helpful when I see Ms. Steele in the courtroom to address the confidentiality issues, because it may, my hope is that it will give us some guidance on exactly what can be said in the substance of the motion. So if that would be all right with Your Honor, maybe we could do that. And I don't know if Ms. Steele would want to be heard on that, but I'm happy to see the microphone to her to go first if she would like.
Well, it's your motion.
The confidentiality motion?
Yeah.
Yes, all right. Well, I'm happy to speak to that to begin with and turn to Ms. Steele as necessary. I will say the following, Your Honor. We filed these three motions, and I'll start with the motion to dismiss, which is where we're, I think, beginning, with the purpose of complying with Your Honor's order and the plaintiff's very broad confidentiality designations, which, as you know, we've separately challenged more broadly. But at this point, our motion to determine confidentiality is sort of a funny name, because we're actually asking that the materials not be confidential, because we believe that at this point, the substance of those materials and the things that the plaintiff originally wanted to keep confidential are now not confidential, and that these things are inherent in the proceedings and should be available for the public to be able to see, to be able to understand what it is that we're saying, to be able to understand what it is that Mr. Belay and his lawyers are saying, to be able to understand whatever ruling that you make, and that we believe that at this point in the proceedings, especially now that we're about 6 weeks away from the trial, which obviously will also be public, that we ought to be able to proceed in public, and both in terms of what the judicial records themselves say and in terms of the hearing that's about to follow on the substance of that motion. So that's really where I think we are on this. I'm happy to speak a little bit more in detail, but at this point, the burdens, as I think Your Honor recalls from the last couple of hearings we've had on this, the burden is on the party that seeks the closure or sealing, and so perhaps it might make sense if that in fact is continued to be opposed. There was no, as I understand it, there was no written opposition filed to those motions. but if they are in fact opposed by the plaintiff, it might make sense for, him to articulate to us, to you, to the media, to Ms. Steele, what it is that he believes still requires sealing and what is confidential. And so with that, that's really, I think, all I would have to say about it, unless Your Honor has any questions.
I don't have any questions yet.
Okay.
Thank you, Mr. Brewer. Mr. Harder, was there anything you wanted to say, please?
I think
Mr. Bowe?
And just very briefly, Your Honor, you've already entered an order determining that all of these documents are confidential and attorney's eyes only. It's dated September 23rd of last year. These are all documents related to the FOIA materials and the extortion investigation and discovery on other related issues. So I don't think that at this point there's any reason to unseal any of those materials, and that ruling in fact is up before the second DCA on a petition that the Gawker defendants filed.
So let's talk about this for just a minute. Talk about the practical ramifications. One thing are the documents, the other thing is testimony at trial. So is it the plaintiff's position that because those documents are sealed, is the plaintiff taking the position to all the way out there that those documents and the contents thereof would not be appropriate for questioning at trial?
We're not taking that position. In fact, we submitted the attorney's only memorandum of law requested, and we cited a few cases in there, a Supreme Court case, as well as a couple second DCA cases. The Ryan case was one of them. But essentially what the second DCA and the Supreme Court have said is that when you're dealing with privacy-protected discovery, such as what we're dealing with here, what the court needs to do first is conduct an in-camera review to determine whether or not those documents are relevant. When we get to that point, Your Honor, when we're going into trial, if you determine that some of these documents are relevant, then we'll be at the stage of the process to where then those things could be used at trial, which is what I said a few hearings ago, is that if they believe these things are relevant for a specific purpose, then bring that up to the court's attention, let the court review, and then we'll proceed at that point.
But it seems to me that there should be groups of subject matters, topics. Is it appropriate for questioning at trial to be, how did Gawker get the tape? How was the tape made in the first place? How did the tape leave the desk that it was in? All those kinds of topics, I think, are appropriate for questioning at trial. All the various FBI investigations and some of those specific documents themselves, they contain, to me, a lot of information that, one, is not relevant, and two, could be more harmful under the rules to the plaintiff, which aren't appropriate for the trial. So I do not want to waste the jury's time with objections at every question. So if there could be certain topics that we could go over separate and then apart from the attorney's eyes only designations, some of those, I think it would be really helpful to everybody.
And I think that's what we were envisioning, Judge. I don't think we're going to preclude anyone from asking the questions that you were talking about. Our issue is the attempt to use the documents themselves for purposes of hearings like today and for trial.
We're going to get into it more on the, I've got it as number 3, the access to the corrected DVDs, which I've not seen. And I understand that Judge Case has them in the safe deposit box with all the other information, or all the other DVDs that have been produced. And maybe today would be a good time to go through some of those individual topics while Ms. Steele is here as well. Or perhaps during a break, you all can maybe sort of talk about some of that stuff. Okay.
Thank you.
Mr. Berlin, did you want to say anything?
If I can just make one comment, and then I'm happy to, actually two comments if I may. The first is, Your Honor, the provision of the order that excuse me, that Mr. Vogt was talking about, the September 23rd order, which I think was entered on the 28th, is in fact the subject of a pending writ petition, and that provision has actually been stayed with their consent and by the DCA, so I don't think we can rely on that. More importantly, what was at issue there was...
I can't rely on my order or just waiting for for them to rule?
I don't think that the plaintiff can rely on a provision of an order saying Your Honor's already ruled on something when that provision is not in effect because it's been stayed. But more importantly, that provision dealt with a whole category of documents, all of the documents that have been produced by the FBI. What we're talking about for purposes of today is not all the documents that are produced by the FBI, but the specific records, some of which are FBI records, many of which are not, which are attached to the motion to dismiss for fraud on the court and the other two motions that we're talking about. And that raises the question of whether the public is entitled to see what is in judicial records that are attached to motions that are calling for you to decide, in this case, a dispositive motion or not. That's a different question than how we treat discovery documents. And it's also different, this is the second point that I wanted to make, it's also different from the question that Your Honor asked, which I think is an excellent question, about what do we do at the trial, right? We have a problem for today, which is we have a motion that's going to get heard. We have papers about that motion, and the question is, can we see that? We have a separate question about whether certain documents would be admissible, right? And there's a different standard for whether the jury gets to hear it, and it might be prejudicial or not, versus whether the public gets to see them. So we have cases, for example, where there's a suppression hearing, and the thing that's suppressed, the jury can't hear, but that the public, in understanding what the ruling was, gets to understand what that is. And it's the same thing. So we need to be careful not to conflate the two. That's all I wanted to say. All right. And I appreciate your foreshadowing the practical problem, but there's sort of, there's the practical problem of today's records, there's the practical problem of today's hearing, and then there's later the practical problem of the trial. And with that, I suspect that Ms. Steele might be next, but I'll leave that to Your Honor. So.
It's hard for Ms. Steele to make an argument when she's sort of talking in a vacuum, but Ms. Steele, go ahead. I know you do a good job.
Thank you, Your Honor. I appreciate it. I believe Your Honor's initial question anticipated one of my concerns, which is I am highly concerned that we're heading toward a courtroom closure here, possibly for today's hearings and possibly at trial.
I don't anticipate that.
Thank you, Your Honor. I thought that would be very unusual for you to rule. With respect to what I'm understanding is presently sealed with respect to today's hearing, there are 3 motions filed by Gawker and the omnibus response in opposition filed by Mr. Belia, all with form motions, essentially. If I'm understanding Gawker's counsel correctly, they are not advocating for the sealing of their papers, whereas it sounds like Mr. Belia is advocating for the sealing of the motion papers and the response. I just want to make sure I have that right.
Yes.
Okay. When I go back to Your Honor's original agreed protective order in July of 2013 governing discovery documents, I saw a very limited category of materials that could be designated confidential and then could potentially raise an opportunity for one of these motions to determine confidentiality. And they were medical and financial records with respect to health care providers of a party, sensitive business or proprietary information, and then other information where a party has a reasonable expectation of privacy or confidentiality. And the order seemed to contemplate that the supplying party or supplying witness would be the one to assert this confidentiality issue as limited by this order. And it seems that since then, based on just the sheer volume of material that's sealed in the court file, that has expanded. And I'm still actually trying, Your Honor, to understand at what point...
I'd say exploded.
Agreed, Your Honor. Agreed. At what points and how that has become sort of the global governing procedure for filing things in this case. I know Your Honor will agree with me, that's extraordinary. In cases before Your Honor, in the 6th Judicial Circuit and in Florida. One of the things I would like Your Honor to do going forward, and especially with this motion to determine confidentiality filed by Mr. Belia today, is the rule 2.410 requires that motions of this nature have specificity in them. Identifying the information as specifically as possible without revealing it, specifying the bases for determining it confidential, and the legal authority. And Your Honor keeps looking at form motion after form motion. I think the court is entitled to have the lawyers do a little more work.
Well, thank you for that. I will say to you that I think it basically exploded once I required Mr. Belia to sign the Freedom of Information Act for the FBI case. Gawker brought a separate suit against the FBI that has been ongoing for quite a while now with Judge Buckley over in Tampa. For the hearing today, I received 4 boxes of documents from the defense and a notebook, 2-inch notebook from the plaintiff. So while I appreciate you want me to make them do more work, I think this is like the Lawyers Relief Act, so I don't know that they can do much more work. There are many more lawyers that work on this that aren't here in this courtroom.
I understand.
And I know the court is very stretched for resources, and I can't review any more documents. It becomes very cumbersome and difficult for just one person. It's not like I have an army of lawyers. There are no other lawyers, in fact, to manage all of that. In some regards, I believe it's been almost an abuse of the system, and I don't say that in a negative way, because I think it's certainly been appropriate for the defense to have the right to investigate certain things, but as more information became available, I can't tell you how many versions of certain documents I've seen redacted in sundry different ways. So I don't have the time to go back and say, okay, well, at this hearing they gave me this version, at the other hearing they gave me another version, at another hearing they gave me another version. So it's multiple versions of the same basic cut and paste document. Authenticity is a huge issue in this case, which from an admissibility standpoint for the jury would be totally different from the discovery standpoint. Much of the things that I have seen, are really not, one, they're not part of this lawsuit. I think they do more harm to Mr. Belia for the public to have access to everything, which I don't think that they, under the rules, need to have access to any of that, specifically for this lawsuit. And when I hear from the different attorneys that, well, Judge so-and-so said this, or Judge so-and-so said that, and it's permissible there, each of us as judges, Judge Buckley has a different standard of review that she's looking at, the second DCA has a different standard of review that they look at, and I think I'm the basic gatekeeper for this particular trial. So I would really, I'm sure you're calling them form documents. I don't think they're form motions, but because I don't think this is a common type of a case, but it certainly seems to be becoming more common as we see about the Mattel suit, Barbie, and the models that were in the newspaper earlier this week. So maybe they will become form type documents. But I think that all the attorneys that I appreciate are trying to be as vague as possible, but also giving me specific clues as to what they're talking about.
And I appreciate that the court's deep familiarity with the case would lend itself to some shorthand. And I understand that completely. I also have a deep personal appreciation for the workload that Your Honor is shouldering in this case. What we're looking at today are 4 entirely sealed legal briefs, arguments to the court, putting whatever may be attached to them aside, 4 legal papers asking for the court's action. I would ask, Your Honor, that the legal arguments of the parties, the legal briefs of the parties, not be sealed.
Okay. Thank you.
Thank you, Your Honor.
Why don't we take just a brief break? Let me go look specifically at that what Ms. Steele just brought up, and I'll be back in a second.
All rise. Court is in recess till the calling of the court.
Rules.